If this is granted, then all hell's going to break loose in Parliament. Let me tell you that.
Ladies and gentlemen, we have breaking news that the courts have rejected the government's argument that the challenge to prorogation is not urgent. What this means is that the courts have declared that the challenge is in fact urgent and must be addressed as quickly as possible.
Let's take a look. Ladies and gentlemen, we present to you the decision from the federal courts on the motion for essentially the expedited review of the court challenge of prorogation. Now, this literally just came off the presses today. The challenge decision was issued today by the court, and we're going to take you through just a bit of it to kind of explain what went on and what the decision means. So, this is the front page of the decision. This is a public document, so it is available for everybody. We are not violating any privacy laws by showing you this. So you can see the applicants on the top. They're not plaintiffs in this case because plaintiffs are usually categorized as such in a legal lawsuit or something like that. This is not a lawsuit. This is a challenge, which is a little different. So they are applicants, and you can see that the respondent, or in other terms the defendant, but in this case it's the respondent, is the Attorney General of Canada, essentially on behalf of the government. So let's get into this. This is essentially the meat of what James Manson and his clients are putting forth as a motion. So it says, among other things, the application requests an order setting aside the decision by Prime Minister Trudeau, the Prime Minister, to advise the Governor General of Canada, the Governor General, to exercise her prerogative power to prorogue the first session of the 44th Parliament of Canada until Monday, March 24th, 2025. The decision. The application also requests a declaration that this session of Parliament has not been prorogued. So what does that mean in normal
Layman's
speak?
terms? Yeah.
So it's essentially saying that the decision by the Prime Minister to ask the Governor General to prorogue is in fact not valid. And the second part of that paragraph is essentially saying, because it's not valid, that Parliament has therefore not been prorogued. And what that would mean is if the court does actually find that that is the case and grants the challenge, then Parliament would no longer be prorogued immediately as of that decision.
Right, and that means that all the bills would come back, including some of these disastrous bills like Bill C-63 or Bill C-65 in order to change our election laws. But we suspect if this decision does go through, meaning that Parliament will not be prorogued anymore, it will have never been prorogued, then the opposition parties will come together as fast as they can to dissolve Parliament, to vote down the government, dissolve Parliament, and then we'll go to election. So what's going on with these bills doesn't really matter too much.
Well, and we'll get to this later. If this is granted, then all hell's going to break loose in Parliament. Let me tell you that.
Because this is totally unprecedented.
But just some other things so you can understand how these documents actually work. So you may be wondering why it says the Prime Minister in bold after it says Prime Minister Trudeau, why it says Governor General in bold, and why it says decision in bold. What this means is because the author of this document doesn't want to keep writing it Prime Minister Trudeau every single time that they write this, just like Governor General of Canada and the entire decision that she actually made. What this means is they are converting it into kind of a shorthand to use throughout the document. So this is the only time in the document that they're going to refer to Prime Minister Trudeau as Prime Minister Trudeau. The rest of the document, they will refer to him as the Prime Minister. Now, the biggest shorthand here is basically to exercise her prerogative powers to prorogue the first session of the 44th Parliament of Canada until Monday, March 24, 2025. That gets shorthanded to the decision. So you can understand, the reason for converting some of these things to that. And this is where the legalese actually begins. So that's the first bit. Now, what is going on here in terms of the justification of this motion to expedite, which is different than the original court challenge, right? So the original court challenge is we dispute that the Parliament should actually be prorogued and the decision was valid. This is asking the court to essentially convene as soon as possible in order to actually look at this. And if it's granted, then they don't have to wait months or even years to actually have this go to court. So let's take a look at another page of this document. So this is the justification by James Manson and his clients that this is urgent and must be looked at now. So the numbers next to these paragraphs are in fact that. It's the numbered paragraph of the document. So this is paragraph 3. The applicants maintain that their application is, quote, truly urgent and requires the court's immediate attention to determine whether the Parliament can immediately resume sitting to protect Canada's interest in the face of threatened actions by the United States, end quote. Those threatened actions are stated to be, quote, President-elect Trump's stated intention to impose a 25% tariff on all goods entering the United States from Canada, end quote, on, quote, his first day in office as president, and, quote, the 25% tariff. So all that is shorthanded to the 25% tariff. Now, this is one of the primary arguments of the government why this should not be treated as urgent.
Among other things, the respondent maintains that the courts have agreed to expedite matters in exceptional circumstances where direct or irreparable harm would result from proceeding in accordance with the normal timeframes. The respondent states that the applicants have failed to demonstrate any of the types of harms necessary to warrant expediting the hearing of the application. Instead, the respondent maintains that the issues raised by the applicants are speculative, general, and are not susceptible to being resolved by the remedies sought.
So what does that all mean? What that means is the government is arguing that the argument put forward by James Manson and the applicants that this is urgent because of the 25% tariffs going on, and this could have a catastrophic effect on Canada's economy, among other things, is speculative. And they're not demonstrating that that will for sure happen, and that won't constitute any real harm to the public or the general interest of the country. Now, there's a lot of problems with this argument that the government is putting forward. Mainly the fact that all we've heard from Justin Trudeau and the cabinet is how serious this actually is. This is all we've been hearing for the last few months, since December. So for the government to then turn around and say, well, it's speculative. No doubt this was one of the reasons why the judge looked at this and said, sure.
But on the other hand, you could make the argument that in the case of prorogation, and also in the case of dissolution of Parliament, the ministers still stay on to do their job, so the ministers should be taking care of this whole tariff situation.
Well, and this was another one of the arguments the government put forward. The government said that even in prorogation, the executive branch is still functioning, and that's the Prime Minister and Cabinet, like they can still do things. Now, they also made another argument that, well, if legislation were needed in order to respond to this, then the Prime Minister could declare an order to bring it back anyway.
True.
But the court said, well, yeah, the court basically said no.
Well, on the other side, though, I think the argument, and I think this is where Canadians should be concerned, is that can the Prime Minister prorogue Parliament for his interests or the interests of his party? Because that certainly seems to be what the case is right now, is that Parliament was prorogued to give the Liberals some time to sort out their leadership race. And then when they come back, there's either going to be a non-confidence vote or there's going to be a budget vote that possibly passes. I don't think so, though. I think it's going to go to a non-confidence vote and the government's going to fall at that point. But you could argue that Parliament was prorogued in the first place in the interest of the Liberal Party.
Well, and that's what's going to be in the decision when this is actually addressed. But right now, they're just deciding, is this urgent or is it not? And this is what the government is arguing, that it is not. So, as just stated, paragraph 47, the respondent also notes that the executive branch of government will continue to function during the time the Parliament is prorogued. This includes the government's conduct of foreign relations and economic and trade policy, the holding of cabinet meetings, the making of spending and policy decisions, and dealing with threats to public peace. The respondent adds that the suggestion that economic challenges would require Parliament to initiate a legislative process during the relevant time period is speculative. In any event, it maintains that the Prime Minister retains the ability to advise the Governor General to summon Parliament at any time during prorogation. So again, this is their argument. But if you take the opposing view to this, well, then why do we have government in session at any point anyway, when the Prime Minister can just call them back?
Right. Why do they hang out in Ottawa? Why don't they just hang out in their ridings? And then if the Prime Minister needs something, why don't they just go to Ottawa? Well, because that's not how our democracy works.
Oh, wait, because that's what they're supposed to be doing.
Right.
So, yeah, that doesn't fly. The court orders that this motion is granted. The timeline set forth in the rules for the hearing of application of this court shall not apply to this application. Instead, the schedule for the hearing of this application shall be as follows.
The applicants shall serve supporting affidavits and documentary evidence and file proof of service by January 22nd, 2025. That's next week, folks. The respondent shall serve supporting affidavits and documentary evidence and file proof of service by 10 o'clock a.m. on January 27th, 2025. The parties shall complete any cross-examination by January 29th, 2025. The applicant shall serve and file an applicant's record by February 3rd, 2025. The respondent shall serve and file a respondent's record by noon on February 7th, 2025. Any interveners who may be granted leave to intervene shall serve and file their submission by February 10th, 2025. And the applicants and respondent shall provide any reply that they may wish to make to submissions made by any interveners who are granted leave to intervene orally at the hearing. In that eventuality, they may also each file a written reply of up to 5 pages by February 18th, 2025.
And finally, this is the last page of the document. It was a really long document, so you're welcome for not having to read the entire thing. But this is the end of it, and you can see that the decision was rendered by Chief Justice Crampton on January 18th, 2025. So basically, that sets out the timetable that this challenge is going to follow. And what it essentially means is that there's going to be a decision on Friday, February 14th.
That's Finnick's birthday.
That's Valentine's Day.
And it's Finnick's birthday.
And ironically, this is the ironic thing. That's when the tax holiday ends as well. Like, very strange how these things are working out.
I think the tax holiday technically ends the 15th, or like it's over on the 15th. The 14th is the last day.
Yeah, that's what I mean. So,
yeah.
So what does that all mean? Well, it basically means that the applicants will file their evidence, their proof, their documentation, and then the government will respond to that and file their counter arguments, counter proof, and documentation. Any interveners, what interveners are like third parties that want to jump in on the case, either for the government side or for the applicant side. So the court will decide, am I even going to allow them to intervene? And if they do, then there's some procedures for them. And if there's not, then that may even shorten the timeline. So this is how this is going to play out, folks. There's some dates coming up. Wednesday the 22nd is the first one, and I'm sure James Manson and the applicants are ready for that. Now, what could be the result of this? This is where it gets very interesting. So you end up having a scenario where if the court rules on February 14th that the prorogation is invalid and that the Prime Minister was wrong and his recommendation was quote unquote illegal, then what that means is that the court is ruling that Parliament is no longer prorogued. What does that mean? Well, that means that the minute that that decision comes down, Parliament is in session, because it would follow that Parliament would resume the session in the very next sitting, nullifying prorogation.
And all those bills come back.
So given the fact that Parliament were to resume session January 27th, which is coming up, and February 14th is after that, well, as soon as that paper is signed, Parliament's now in session.
Yeah, it could come back as soon as the next business day. So that would be quite interesting. I think the 14th is the Friday this year, which would mean that the Monday, it could be that Parliament is back.
So what does that mean? Well, I imagine the government is going to decide, do we prorogue or not, do we challenge or not? And here's the thing. It's going to look pretty bad if the government appeals this decision. Like, it's not going to look good.
No, it's not.
And all you're going to hear in the media is about them challenging
appealing this decision, if that is indeed the decision that the judge makes.
Now, what else does this mean? Well, it means that there's a speech from the throne that has to come that the Liberals are not ready for. So now Justin Trudeau, if he's forced to do that, can say to the Governor General, well, we want to delay this a couple of weeks. This is all happening pretty fast. We're not entirely sure how long it can be delayed for, but it cannot be delayed unreasonably. So they can't delay this until, March 24th.
But here's the real question. Is there a speech from the throne at all? Because if they say, okay, the prorogation was illegal.
Oh, that's true. There is no speech from the throne.
Right. They just go straight back to Parliament,
right.
Which means everybody's back in the House and everybody's back in committee, which means the very first committee that is a opposition chaired committee, I imagine they will be putting forward a motion to request that the House of Commons have a non-confidence vote.
Yeah, so that's going to happen at Standing Committee of Public Accounts, and that's going to happen very fast. So, wow, yeah, this is going to get interesting.
It's going to get messy. Like we said, this is entirely unprecedented. We are not even 100% sure what would happen if Parliament were magically unprorogued. We're just guessing based on what we know of procedure. Yeah.
Yeah, so the Conservatives would bring that challenge to committee. At this point, the NDP don't have a choice but to agree with the Conservatives, and the Bloc will as well. That could come back to the House in, who knows, maybe in a week. So then you're looking at the last week of February could be a confidence vote in the House against the government. Government falls the last week of February, and then
a leader is chosen for the Liberal Party very soon after.
Well, that's the thing. Parliament is dissolved. My guess is that the Liberal Party, to Tanya's point, will then move to appoint a leader, which is going to be very messy if they choose to do that, because otherwise Justin Trudeau is the leader of the Liberal Party going into this next election that's not going to be done by the time the real leadership race is done.
Again, this is all wild speculation based on what could happen as a result of the procedures that we know to be in place in the House of Commons.
Right. There may be other contingency procedures that are executed here,
or none of this could happen at all. It could be that even with the expedited hearings, that unfortunately the case is lost.
It's possible. But the one thing that I am hopeful for is the fact that the court actually cites the fact that the UK case was expedited. So they're already looking to the UK case as precedent for how to manage this one. So that's actually really good news for us.
That's a good sign for sure.
So, but we're not going to know how this ends up until it's over, right? But this is procedurally, this could get wild.
This is wild because it's unprecedented. This has never happened in this country before, where citizens have come together and said, you know what? We don't think that this prorogation is legal. Let's take it to court and let the judge decide.
Right, and if the government does want to challenge, then the appeal, no doubt, will also be expedited. and then that will go up to the Superior Court. And then if that is appealed there, then that will go up to the Supreme Court.
Another great thing about the fact that this is being expedited is that the whole issue won't be moot. We had discussed this in the interview with James. You can go and check our interview playlist for that one. But basically what it means is that because Parliament is scheduled to come back on March the 24th, if this issue had not been heard by the courts by then, would it be kind of a lost cause to hear it after that point? Would there be any point in hearing prorogation if Parliament returns on March 24th and a hearing for this isn't until, like, say, May? So I think this is a win for citizens because the court recognizes that this is important for our democracy, for our Parliament, and they want to hear it sooner rather than later.
Well, and the mootness factor also factored into the court's decision because they recognize that this is a very, very important decision. This could set precedents for hundreds of years to come, who knows, and that this deserves to be looked at now prior to Parliament coming back. Anyway, folks, procedurally, this is getting crazy.
This is getting crazy, and we're hoping that we can keep up with this and everything else that's going on in this country right now. But if you want to stay absolutely up to date on this case and know exactly what is happening when it happens, go make sure that you sign up to the Justice Center for Constitutional Freedoms, or the JCCF. We're going to put a link to their YouTube channel in the description so that you can go over there, sign on, ring that bell, and you'll be up to date on everything that is happening with this case.
So here we are, folks. Round one to the citizens of Canada.